Thank you for being here. A bit about your background is you're a Professor Emeritus at Western Law School, and you taught at many other universities along the way, specifically in the field of wills and trusts and estates, most notably. Your career was for the most part in academia, which means that you are a very frequent publisher, including of several books: Oosterhoff on trust, Oosterhoff on wills and succession. You are what I consider a voice of reason in the estates community of lawyers. Your articles, which I endeavor to read, are a way to learn the depths of the law and keep up to date on current events. Just a note, so all the blogs at the Well Partners law firm, all very relevant, good blogs and a useful resource. We'll try to touch upon the two main parts of your career, the academic wills and estates academic, if I may call it such a thing, and then the second part as counsel at Well Partners. It sounds like a very incredible career you have. But before we get to the career aspect, I always like to start by asking about your background. If you want, even pre-university days, I'm curious to know what prompted you to study law. How did even you come to study law?
Very good question, Avi. I was born in the Netherlands in 1940, just a couple of months before Germany invaded the Netherlands. And then I came to Canada with my family in 1952. Yeah. So I was 12 years old at the time. I had elementary school education in the Netherlands, so I know the Dutch language. So then, of course, I had my high school in Canada and then went to university, Western. And I started, the first year, of course, was one of those years where you had to take a certain number of subjects. One of them was economics, and I got a very good grade in it. And so I decided to focus on economics. So in second year, I think I had 3 economics courses, but then I realized that economics in the upper years is mostly focused on mathematics. Mm-hmm. And Avi, I suck when it comes to maths.
Me as well. That pushes us to law, hey?
That's right. So then, Western Law School was then in its second year of operation. And so one of my classmates from economics and I decided we'd walk over to the law school and see what that was all about. And so I filled out an application and I was accepted. So after 2 years of undergraduate work. So the answer to your question, how did I decide to study law and become a lawyer? It was a bit of an accident, actually, but a very happy one, it turns out.
Right.
So, yeah.
And how was that experience? You enjoyed the law school experience, and I mentioned before that your career was largely in academia. Were you attracted to the academic aspect of law from those law school days, or how did that come about?
I was attracted to academia from those years, yes. I had some very good teachers in law school. I'd just like to mention a couple. The first is Dean Ivan Rand. Rand was a retired Queenie Justice of the Supreme Court of Canada, and then was regarded, frankly, as sort of the best on the bench. Perhaps that's a bit of an exaggeration on my part, but we loved it. He was a great teacher. He taught me 3 courses, actually. In first year, it was history of law, and second year, it was equity and constitutional law. And of course, he was an expert on constitutional law. So that was wonderful. The other teacher that I want to mention is Ralph Skane, who went on from Western to then went back to practice, actually, but then he taught for the rest of his career at U of T. Ralph taught me both wills and estates. And that's where I got my love for those two topics.
Wow.
So, but then, yes, so I became interested in academic study when it was, I guess, towards the end of my second year. I approached Dean Rand about it, and he said, and he gave me very good advice. He said, "Look, that's a good thing to do, but I encourage you first to go into the practice of law and see what that's like. Because," he says, "if you don't do that, you'll always wonder what you missed."
Uh-huh.
And it was excellent advice. So I went the route of the bar admission course, articling bar admission course, and then called to the bar, which was in 1966. And then I practiced with a firm in London for 2.5 years. I also articled with them, an excellent firm. But in the meantime, I wanted to continue my academic studies.
Yeah.
So I finished off my BA actually part-time while I was working for the firm, and then I went to U of T to do my master's, and then
Did you have to specialize to do your master's? Did you pick wills and estates at that point?
I did take. I didn't take wills because I focused on that a lot. I did take a trusts course and a couple of other courses as well. Not from Skane, because of course he had taught me at Western, but he was there by then.
Okay. And your practice, those few years of practice, were you really trying to specialize at that point in the trusts field, wills and trusts, or were you just trying to gain a bit of practical experience?
No, I can't say that I was really trying to specialize at that point. When you're a young lawyer, you've got to do most anything that is presented to you.
Right.
But I knew that I was not a barrister. I was a solicitor. So I did a lot of work in real estate transactions, corporate law, corporate commercial, and also some wills and estates.
Wow.
And I really enjoyed the latter.
Mm-hmm.
So.
And that's kind of what prompted you to return to what you always wanted to do, which was teaching. And you had such an outstanding career as a professor, as an academic. You were associate dean, you were a dean at some point, and you were involved in all sorts of universities and teaching arrangements. And can you talk a bit about your experience there and looking back on it?
Yes. I started teaching at the University of Windsor. I taught there for 3 years, and then I moved back to Western.
Yeah.
And that's where I spent the rest of my academic career. When you first start teaching, it's not an easy thing to start to do, right? It's something entirely new. You've had mentors in law school, of course, and that helped a lot. But it took me a while to get into writing and publishing. So the first 2, 3, 4 years are you're really focusing on how to prepare properly for your lectures, how to teach effectively, and get the material across to your students. But then I started to write and to also do some work for other bodies, especially the Law Reform Commission of Ontario. And that also, of course, involved a lot of research and writing. So all of that was right up my path.
Right.
And then, towards the mid-70s, I started to write articles and books. And then ultimately, I wrote my Wills and Trusts texts, which were first published in 1980. Trusts is now in its 9th edition. And Will's 9th edition will be published next spring.
Unbelievable. I want to get a signed copy at some point.
I'll arrange it.
Yeah, it's really unbelievable, the amount that you publish, and it sounds like you had to really work on that at the early part of your career, the first 2 years. I'm in the early part of my career. How did you develop such an output, if you can call it that? The first part of anyone's career, especially as a lawyer, is all about input, receiving information, trying to learn as much as you can. And I think that tipping point, what turns you into an expert or a better lawyer, a more experienced lawyer, so to speak, is when you start with the output. And that's one of the things I'm trying to do over here is output of information. But I'm a drop in the ocean compared to your output. Even until today, you publish articles, once every 2 weeks or whatever it is. And each one I look at is well thought out and researched and clear. And how did that skill develop? And how even do you go about it today, producing so much?
Well, I think to begin with, I should say that I've always loved learning. Mm-hmm. My family was a reading family. All of us read, and it was for enjoyment, of course, but also for learning. And that continued when in law school and then in university. Sorry, I said law school, I meant high school. Mm-hmm. I had a good time in high school. I loved the English classes in particular, and history. In those days, you had to memorize reams of Shakespeare and various poetry and so on. I can still recite them. Mm-hmm. I won't bore you with that now, but I can. And so it's almost a need to learn, Abby. That I had. And then when you start to teach, that need to learn evolves also in a need to pass that on to your students, to a younger generation, if you will. And so that's why you research. That's also why you write, so that others can benefit from your work, from your studies.
Yeah. Absolutely, and they are, no question about it. I feel that's part of the duty as you gain more knowledge and experience is to share it. That's definitely part of it. Have you ever had some sort of a writer's block, they call it?
Oh, yes. It's not at all uncommon, I think, for most people. In my case, I may have finished some major project, and I know I've got something else that's coming up, and I've got to work on it. But it just doesn't work. It's not coming together. So I leave it for a week or two. And then I may still not have the thoughts in place to start working on it, but I'll just start to write. And it may not make all that much sense to begin with, but I'll just write away. And then I'll print it up, and then the next day I'll look at it, and I'll probably discard most of it, but I can save some of it, and then things start to gel for me, and then I can work away on doing a good job with it.
Wow, amazing!
Sorry, go ahead.
No, I didn't hear you.
I was going to say, even then, it requires a lot of editing afterwards. I can't just write a piece of work like an article and submit it for publication. It requires rewriting, editing, rewriting again, and then finally, when I'm satisfied with it, then it gets submitted for publication.
Right. Yeah, it's a piece of art, a sculpture. Yeah. You have to keep amending it. And you've also been, I call it a legal innovator. You shed light on future events, how things should be. This question could go in many different ways, but I'll start by asking retroactive. Have you seen major developments in the estates world throughout your career that you'd like to comment on? I spoke to Don Carr. He was my first guest, and he said he was involved in the multiple wills, which is a huge thing. If there haven't been changes in the past, the follow-up question is: do you think there should be any changes going forward? And I'll just comment one thing about the electronic wills and all the software that's available. Do you have a take on that?
In fact, I was going to talk about electronic wills. In the estates area, there haven't been that many changes. Carr is right, of course, about the multiple wills, and that was because of the huge increase in estate administration tax. Mm-hmm. So then people decided to have a primary will and a secondary will, one of which is probated, the other's not, right, to avoid having to pay so much tax. But there aren't many of those changes in wills. We had the Succession Law Reform Act passed in 1965,
I think. No?
No, 1977.
Okay.
And that introduced some major changes, including, for example, holograph wills. But they were not sort of earth-shattering changes. They were just developments from the past. But things are moving much more quickly now. And when we think about it, so much of our work is done electronically now. I mean, I sit at my computer most days and type whatever I have to say on my computer, right? And then I pass that on electronically to a publisher or to my law firm, as the case may be. And all of this is stored electronically as well. Mm-hmm. We haven't done that with wills, right? But now, because of COVID-19, things have started to change. Mm-hmm. Particularly because all of a sudden we realized, hey, people can no longer execute their wills because we have to maintain social distancing, so we can't go to the people. So we can't have them in our offices either because of those restrictions. So what can we do instead? And so Ontario was one of the first, but all of the other provinces followed as well, by passing a ministerial order under emergency legislation that permits virtual execution of wills and powers of attorney and so on and so forth. Those were temporary solutions. They were good solutions. They needed to be made, but of course they don't work for everybody, especially for seniors who really need and want to make wills. It doesn't necessarily work for them because they don't have access to electronic devices, right? And they're not capable often of accessing them. So other things need to happen as well. So electronic wills is one of them, mm-hmm. And that's been discussed for quite a number of years. There are now a couple of jurisdictions in the U.S., Florida and Nevada, that have electronic wills legislation. There's also a Uniform Wills Act in the United States. And the Uniform Law Conference of Canada has also got a working group which is well advanced on proposing similar legislation. And then most recently in British Columbia, they passed legislation to be part of their wills statute on electronic wills as well. So we're moving ahead, and there's interest also, for example, here in Ontario about electronic wills. I don't know if it's going to happen soon, but the interest is there.
So can you just clarify what that means exactly? Electronic will means it's stored electronically and there's no hard copy. What does it mean regarding signatures? What's the definition of an electronic will?
There are many definitions, actually,
yeah.
But you've covered the essentials. It is stored electronically in a safe way, and there's only one copy, of course, that is stored.
Yeah.
Then if amendments have to be made, that can be done, and then the original is changed, of course, but there is a there is a track that can be followed. So you have the original and then you have the amendments made. The signatures are still required, but they're electronic signatures. So they're like the signatures that are being done now, electronically, virtually, right? But they're still necessary.
Uh-huh.
So that hasn't changed.
And do you think there's going to need to be a certain digital custodian, or the client can keep their one?
Yes. Those are mostly commercial organizations now. That may change. I don't know.
Mm-hmm.
But yes, the need for secure storage of these wills obviously is very important.
Mm-hmm.
There is another point to notice too, and that you actually mentioned it. The will is entirely electronic, but it is capable of being printed, and that's still necessary, of course, in the probate environment that we're working with today. The court wants to see a printed copy, but that's changing too, because today in the wills practice, you can submit, for example, a probate application electronically.
Right. That's you.
Right? So all of these things are changing. And that's mostly because of the COVID-19 restrictions.
Yeah.
So there are events that cause these changes, just like the multiple wills that was caused by the huge increase in estate administration tax. Now COVID-19 is causing these changes, and they're good changes. We need to move with times.
Yes, yeah, absolutely. The wills signing digitally. I'm the solicitor as well. I've done a few of those remote signings by counterpart and putting it all together. But I must just note that I think today is October's 21st. It should be expiring, the emergency order, tomorrow. And I've heard nothing about whether it's extended or not. So from tomorrow onwards, I think people are in the dark a little bit over there.
Yeah.
Have you heard anything?
No, I haven't. I do know that it's a matter that the Ontario Attorney General has under consideration.
Right.
He held a couple of virtual chats with members from the bar, where he sought advice on various things, and that was one of them. But I haven't heard what's happening with the virtual signing. Another thing that's under consideration is introducing the power to rectify a will when it's not quite up to snuff. The execution there's some problems with execution. And virtually every other province has enacted such legislation. So we're out in left field, and the feeling is that we need that kind of legislation as well. Yeah. So again, a change that's important, and that I think is certainly coming in Ontario.
Uh-huh. Very interesting. Changing times, if you will. There's a lot of developments on the way. I don't know if it's fair to ask you about other jurisdictions, but maybe as part of your research, you know what's going on in other places. I'm a lawyer in Israel. I just spoke to one of my state's colleagues there recently, and it's interesting how different countries have dealt with the COVID. Over there, I don't know if it's dealt with the best way, because there has not been a virtual allowance of a virtual signing. So people who need a will now are just out in the dark. And what the government's done, it's interesting, is promoted individuals to do it themselves, which means they've provided a guideline of how to make a holographic will, how to find two witnesses if you're going to type it up yourself. And lawyers are left either out of the picture or just providing a will and giving instructions to the client how to get it signed themselves. So I am impressed with the way the Ontario government's dealt with it, allowing these things, emergency orders. I'm hoping this will accelerate things for the future and allow us to continue the whole digital world. But do you have comment on other jurisdictions and how they've dealt with this? Are you aware of such how people have dealt with COVID in general?
I'm not too familiar with it. I read information about other common law jurisdictions,
Yeah,
and they've taken similar approaches to what we've done in Canada.
yeah,
I'm concerned about leaving it up to the test leaders themselves to prepare a holograph will. Yes, of course they can do that, but as you well know, holograph wills often cause all kinds of problems, interpretation, problems with the proper execution, that sort of stuff.
right.
So you're asking for trouble there.
Yeah.
Yeah.
Another question about changes is about the law itself, substantively. So you mentioned the Succession Law Reform Act is from 1977. And I know the UK, I think in 2014, updated their intestate laws to kind of more accurately reflect society. So they excluded parents and siblings and included a common law spouse, for example. They also have this preferential share, which they increased and indexed to inflation. So I've heard about the Succession Law Reform Act. That's the law, for those who don't know, that applies to our wills and estates. Do you have a comment that that should be updated in any way?
Oh, yes. I think that it should be updated very much indeed. And I've said so to our Attorney General. It's more than a quarter century old. In fact, what is it? 45 years old, something like that. And there have been a lot of changes since it was enacted. And some you've mentioned, common law spouses are not included. Of course, you can make a will in which you benefit your common law spouse.
Right.
But when you die intestate, the common law spouse is not included. Mm-hmm. In all of the Western provinces, I believe, the intestacy laws include common law spouses. The drafting can be difficult because what do you do, for example, if you have a common law spouse, but you also have a former, you still have an actual spouse, although you don't live with that person. And then when you've got the preferential share, who gets it? Right? So careful drafting is required in those circumstances. But yes, those are reasons to suggest that we need to revise the legislation.
Mm-hmm. Okay. There's other, by me being a foreign lawyer as well as an Ontario lawyer, I have insight into how other jurisdictions practice. And one of the major ways they practice in Israel, for example, is for the drafting lawyer to insert themselves as the trustee of the will. They seem most familiar with the financial circumstances of the person, and they were involved in drafting the will, so they feel like they could administer the will. Here, it's frowned upon. Question is, do you have any practice? I know you're not a practical lawyer, but even from an academic point of view, any practical nuances, challenges, or issues you want to discuss?
When you as a solicitor suggest to a client, why don't you appoint me as executor of this will, because I know all about you and your affairs, you're in a conflict of interest, right? That's improper. On the other hand, if the client says, I want you as my executor, that's a bit of a different story. And then as a solicitor, you have to point out, well, look, this sort of thing is not really, it's really frowned upon in Ontario. It can be done, but you have to be aware of that.
Right.
That's your obligation to point out to your client, right? I'm really in a conflict of interest. So in general, I would say don't do it. It's not a good idea. Mm-hmm. Because of the conflict of interest.
Right.
It does happen.
Yeah.
No, often as not. often as not, you're dealing with a single lawyer in a small community, and that lawyer looks after all the client's affairs, and yeah.
Right. So talk a bit about your current role at Well Partners. I mean, Well Partners is really a real leading estate litigation firm in Toronto. I love some of the people that work there. And just discuss your role of counsel there. What exactly do you do?
Good question. Let me see. After I retired at Western, 2005, I moved to Toronto, and I then taught trusts at U of T as an adjunct for about 7 years, I think. And that was good, but when you as an academic, your pension isn't all that great, so a little more income doesn't hurt.
Yeah.
And frankly, teaching as an adjunct doesn't earn you that much money. So I happened to be talking to Kim Whaley at some point, a lunch and learn kind of thing, I think it was. And I said, I really think that I'd like to get back into practice a bit. And she said, well, come to my firm. And so I've never looked back since. That's been a most fortuitous in some sense that I ended up with Well Partners, but also a very welcome event, because Kim has been very good to me. She's welcomed me with open arms into the firm. To be fair, I think she and the younger members of the firm rely on me for legal advice, and I enjoy doing that too. But it's opened all kinds of possibilities for me. For one, the blogs you mentioned. I blog regularly on the web on the Well blog site. On new cases from all over the world, including, of course, the Privy Council and House of Lords cases. And I wouldn't necessarily have had that opportunity without being counsel to Well Partners. By the way, a counsel, when you're counsel to a firm, it can mean any number of things. In my case, it means that I do opinions for the firm on cases that they're working on where they need some further input on the law. I also do opinions for other lawyers, by the way, who contact me through Well Partners, and I'll do opinions for them as well. But that's done through Well Partners, in other words. And then Kim has me involved in doing CPD programs on a regular basis, and also giving lectures on a regular basis. I did some lectures at Western, for example, last year, because Well Partners put on a estate litigation course there. So that was fun. And then just quite recently, as you know, I did a lecture at Oosterhoff Law School. That wasn't done through Well. They just approached me, and that was fun too. So yeah, those are the sorts of things that I do at Well Partners.
That's great.
It's fun, actually, working with especially with the younger members of the firm. It's embarrassing in some ways, because they kind of put me on a pedestal, and I don't feel comfortable being on a pedestal. But they ask for my views, and I'm always happy to help them out.
Yeah, great guys, Daniel and Matt specifically. I know personally, really good lawyers and good people.
Yeah.
So explain more maybe about these legal opinions. It's the main part of what you do there. So what type of cases require a legal opinion? Maybe you can give an example with some facts, if you don't mind. And then what does a legal opinion do to a case? Have your legal opinions swayed the scales of justice one way or another? You can start with the cases. Give us a couple of examples.
Okay. The opinions can be needed in any number of cases that involve just a small amount of money, or cases that involve millions. What they are about typically is what the law on a particular point is, because what the judge at first instance said doesn't sound right? Mm-hmm. It seems to be off. And so one of the parties, of course, wants to appeal. And then, of course, what are you going to appeal on? And so then they ask me, well, what do you think about this judgment at first instance? Is it right or is it wrong? And how is it wrong? And what issues should we focus on during the appeal? Mm-hmm. And I've worked over the years on quite a number of really interesting things. Where you really get your hands on something that is very current, but also very important to clients, and you can give it your input. Now, when you do this, excuse me, when I do this, I don't necessarily know what impact that has, what my work has on the outcome, because the judge on the appeal is not going to say, "Hey, Oosterhoff did a great job in this appeal," because the judge won't know about it. It's the barristers who present the case on appeal who will use my opinion, and I like to think that it works, and it has worked indeed in a number of cases, with good results. But I don't get the credit for it in the case itself, in the judgment.
You're a doctor. You're the equivalent of a medical opinion in a personal injury case.
Yeah, something like that. Yeah.
Nice.
As you know, Abby, my opinion cannot be produced in court, right?
Why is that?
Well, because I'm regarded as an expert, right? But a domestic expert cannot give testimony in a domestic case. So, for example, if someone is carrying on a case in Ontario and wants some expert evidence on wills or trusts, and wants me to testify in court, I have to tell the counsel I can't do that because the law of evidence says that that's impossible. It's because we maintain this cute fiction that the judge knows all the law, right? And you and I know that that's not the case. But part of that fiction, too, is that they engage counsel to tell the judge what the law is. But they don't need an expert. They don't want an expert for that purpose. I can testify about Ontario law in a Quebec court, and I have done that, but not in an Ontario court. So my opinions, in other words, are only for the benefit of counsel arguing the case.
Oh, I didn't know that. That's interesting, and maybe that's because I'm not the expert, just yet at least. So how would one get an Ontario expertise? You'd have to bring someone, for example, from Quebec to testify in an Ontario court about Ontario law. Is that what you're saying?
Oh, no. If the issue in the Ontario case involves Quebec law, then you can get a Quebec lawyer to testify about Quebec.
Right, got it.
Yeah, nobody can testify on Ontario law in Ontario.
Got it.
Yeah.
Got it. Okay, interesting. So you have a real niche role over there.
Yes.
Wow.
Yeah.
Fascinating.
Sometimes I do get recognized. I acted. I was asked to be involved in preparing an appeal in an Alberta case. That was in 2006, something like that. And that was about a trust issue. And I worked with Counsel there in Edmonton, and he very graciously said in the factum that it was prepared with the assistance of Albert Oosterhoff.
Wow.
But that doesn't happen very often.
Nice. Well, I've seen your long list of recognitions elsewhere, so you're definitely covered in that sense. You've been such a mentor to the younger lawyers. You even speak about the ones at the firm, but throughout your whole career as a teacher, do you have any advice to the younger generation of lawyers among us, law students, etc.?
Yes. One of them is, and I used to tell my students this already when I was teaching still, one of them is, they used to say the law is a jealous mistress, which is probably a bit improper to say now, I don't know. But at any rate, it does mean that it can occupy virtually all of your time and all of your thoughts. But what I would say to them is, look, you have other responsibilities, and those are in first instance principally your spouse and your family. Spend time with them, make time for them, right? Law isn't everything. Law is very important. It's your career, but it's not everything. Find a good balance in your life, in other words. Mm-hmm. And I've occasionally had emails from students that I taught years ago reminding me that I said that to them at one point and appreciating it. So.
Definitely great advice. Keep your priorities in check.
Yeah. The other advice that I would give to young lawyers is, how shall I put it? It's hard to put this into words, perhaps. The word probity comes to mind. Be
inquisitive, interesting.
Not inquisitive, but rather have integrity, be upright in your character, be conscientious, be honest, be sincere. In other words, be a person that somebody can count on, somebody that people know that your word is your bond, right? That is so important, because if people know that they can't count on you, if your word isn't worth a thing, then your reputation is gone.
That's absolutely right. I could not agree more.
And that reputation is what gets you through life.
Beautiful. Anything else to add?
It's what, it's sort of a religious concept, right?
Yeah.
To love your neighbor as yourself. What it means is you've got to be there for the other person. You've got to listen, not tell them what to do. You've got to listen, advise them if you wish, but be there for them and help them. And let them know that they can count on you.
Beautiful.
That's an obligation, right? That's an obligation we all have.
Yeah. Really beautiful. I think that's a lesson in life more than anything else is, be that good person you spoke of with all those lovely adjectives. That's what life's about. In addition to being a lawyer, but life itself.
And when we talk about that sort of thing, I think back when I first started to practice in the mid 1960s. That was in London, and then the practice was much more verbal rather than written. So if a person said, "This is what I'll do," you could count on that person. There were a couple of firms that, you insisted on having things in writing. But today it is quite different, isn't it?
Yes.
Everything is done in writing. And I think we've lost a lot because of that.
Interesting perspective. Yes. Hopefully we can get some of it back, maintain our integrity, and it'll come back a little bit. I have two more quick questions for you, if I may. One is, I just asked you to give advice to younger people, younger lawyers in general. Can you give advice to the public about the importance of wills and estate planning? Someone who's dedicated their whole career to wills, trusts, and estates. Can you talk about the importance of that?
Yes. It saddens me that so many people don't make wills. And there are various reasons for that. I know for some, it brings the idea of death closer, right? And that scares them. For others, well, I'll get it done. I'm planning to do it, of course, but it just didn't get done. It's important because, yes, when you're a single person, it's not going to matter so much, of course, but it might if you have a fair bit of money and you really would like that to go to charity or to members of your family and so on. You want to have a say in who gets what, then you need a will.
Right.
But certainly, once you are married and or have a partner and you start having a family, then you do need a will for sure to indicate how your estate is going to be distributed. You don't want to leave it to an intestacy when we have rules that will say where the estate goes, but they probably won't agree with what your wishes would be. So you need a will, and certainly, of course, when you get older still and perhaps have amassed somewhat of an estate, then clearly you want to have a will that says exactly where your property should go, and also then you should seek advice from professionals, not just lawyers, but perhaps also accountants, to ensure that the tax can be minimized as much as possible within the law. So yeah.
Right.
Yeah.
Definitely.
So, as a legal profession, we do inform people that wills are important. We even had a wills month, where the Ontario Bar Association has a wills month, right?
Yeah, next month, November.
Right. But it doesn't seem to help enough.
Right.
We're not getting at the population with it.
Right. So this is my penultimate question. What can we do to change that? It's such an important thing, yet statistics show something like 50% of Canadians do have a will, don't have a will, either way. Why is that number so low? It's such an important document to have. It's not that expensive. I hear complaints about people spending more money on their suit blazer than their will, and it's just that's not having your priorities in order. So is there anything, do you think, we could and should do to educate the public and get that percentage higher?
One thing occurs to me. We talked about everything being electronic now, right?
Right.
Why not put the message out there in electronic form, much more than we do now? And also, we can do it on radio messages, for example. Mm-hmm. I usually listen to classical FM, and I hear all kinds of advertisements on there about all kinds of things. But why can't we put a slot on there about making a will and why it's important?
It's a great idea. I'm going to explore it.
Good.
Last question I have for you, and you've been great and informative, and thank you. But as a last question, I know from reading your articles, you are a wordsmith to the nth degree. So the question is book recommendations. I know you're an author yourself, so besides your own books, which are most certainly recommended, you mentioned you're an avid reader. Do you have any titles that pop out that have perhaps influenced your life, your thinking?
Yes. In the nature of things, I don't read a lot of nonfiction anymore because I read a lot in the law, of course. I do read nonfiction, biography, for example. Like the biographies written by Eric Metaxas on Dietrich Bonhoeffer. You don't know about Dietrich Bonhoeffer? He was a German Lutheran theologian, and he was implicated in the plot to kill Hitler. And so he was arrested, and ultimately he paid the ultimate price when they executed him in Flossenburg a couple of days before the end of the war. So
you're going to have to share that title. I'm going to make a list of your titles to share,
okay.
and that's a great one. It sounds like right up my alley. As a reading preference, I'm all into that as well.
The author's name is Metaxas, Metaxax.
Okay.
Yes, sorry, ends with an S. And the title is Bonhoeffer, that's Bonhoeffer.
Okay.
And the subtitle as well, but I won't bother with that. The other one that he wrote that I like very much was Amazing Grace. And that was a book about William Wilberforce, who was, as you probably know, instrumental in seeking for the abolition of slavery.
Mm-hmm.
So those are the biographies. Beyond that, I read mostly novels. Some authors that I really love and always go back to are Anthony Burgess, Anthony Powell, who wrote that 12-volume Dance to the Music of Time. It's a series. It's a novel about ethics. How you behave in society, that sort of thing. Tolkien, of course.
Uh-huh.
I love medieval mysteries. So Ellis Peters and any number of others. A good legal author, by the way, is, I don't know if you've heard of her. She's Sarah Caudwell, Caudwell. She was an English barrister, and she wrote four legal mysteries, which focused on, or which featured a number of young barristers practicing in Lincoln's Inn. Really good stuff, well written. I only read stuff that's well written.
Of course.
And especially if it has classical references in it. So those, certainly, Hilary Mantel, I love her stuff. The Wolf Hall trilogy about Thomas Cromwell.
Mm-hmm.
That's good stuff. Let me see. Some recent books that I read. Again, great stylists. Delia Owens, Where the Crawdads Sing.
Well, I haven't read these. I'm still at the non-fiction phase of my life. Okay. And I look forward to getting to that fiction phase when I can turn off all the legal stuff. But I'm going to need a list of those, and I'll include them in the notes.
I can send them to you. One other one I wanted to mention was a book by Ariel Lawhon, Lawhon, called Codename Hélène. This person was an expat Australian who moved to France early on. Still as a late teenager, I think. And she became involved with the resistance during the Second World War and was very instrumental in guiding people out of occupied France, Jews and others, and eventually came back and headed a resistance in the Auvergne that was instrumental in making sure that the Germans that were still holed up there were prevented from interfering with the Allied advance. So it's a great, that's a novel about an actual person, right? So it is fiction, but it is also about an actual person. So all kinds of good stuff.
I'm going to take a look at all of them. I'm building up a book list and going to go through them, but I love these recommendations and I thank you.
You're very welcome.
Thank you for being here as our guest, Speak to a Lawyer podcast. Really appreciate your time, your insight, your wisdom, your experience. And like I said, even beyond this conversation, I thank you for your sharing of that wisdom, your publications, etc. We all get so much out of it. Is there any final words before we let you go?
One thing that always struck me is a quotation from Heinrich Heine. Heine was a German poet and playwright who lived in the 18th century. He was Jewish, and he wrote in one of his plays, he said, Dort, wo man Bücher verbrennt men am Ende auch Menschen.
What does that mean?
What that translates as is where they burn books, they will end up also in burning people. And of course, that's exactly what happened in Nazi Germany.
Yes.
First, they burnt all the books of people the authors that the Nazis didn't like, including Heine's books. But then they also ended up burning people. That's
right. I've heard that quote before, and I didn't know where it was attributed to, who it was attributed to. So thank you for sharing, and it's a deep insight.
It's something that we keep having to remember, right, and to not forget.
Yeah. Absolutely. We'll continue this conversation. Thank you.
I'll send you the list of books.
Okay. Be in touch with you soon. Thank you so much.
All the best. Bye-bye.
Bye-bye.